Hello, my name is Dowdney. I'm a partner in the corporate and commercial team at IBB, based at the office in Uxbridge. And I'm going to do a very quick video on some of the consideration issues that we have seen recently in UK M&A deals, particularly private deals. When I say that, I mean deals involving private company as opposed to public company takeovers. And I think what is the interesting issue is that significantly earn-outs or some form of deferred payment has become increasingly popular to bridge the gap between the expectations of the sellers and what a buyer is prepared to actually pay for the business. Often a business owner will feel that his business is worth a certain EBITDA multiple or however else the valuation is being calculated, whereas a buyer will have carried out their due diligence, will have some areas of concern as to the future potential viability of the business, and certainly one would anticipate the growth expectations of the sellers. And there is often then a gap between what a buyer is prepared to pay and what a seller is prepared to accept. And what has become a well-trodden path is the use of earn-outs to bridge that gap. And the way an earn-out would work is that the buyer will say, well, I will pay you a certain amount up front, and I will pay the rest over a period of 2, 3 or 4 years to bridge the price that you want to get now and the price that I'm prepared to pay now, but to hopefully ensure that if the business performs as you say it will over the intervening period, you will get your full amount of consideration that you believe the business is worth at a date in the future. Now clearly the danger for a seller in that is that there is a period of time whilst they are at risk because they are only getting paid on the performance of the business, but they are not actually in control of the business. So it opens up a considerable can of worms and indeed some interesting drafting for the lawyers as to giving the seller some sort of protection during that earn-out period. And there are all sorts of very tricky negotiations around what level of control can a seller require during that period, how can they restrict the buyer from operating the business as it wishes to, what happens with synergistic benefits that the buyer will get from operating the business, should they go to the seller or should they only be for the benefit of the buyer. The buyer is very likely to want to consolidate the business post-deal into the rest of its group. That will create issues. So actually being able to separate what the seller can get, how the seller can calculate the value of the business in 2 or 3 years' time post-transaction from the reality, which is that the buyer wants to acquire the business and run as it wishes, does create significant difficulty around using an earn-out type structure. However, they have become increasingly popular and indeed have become a reasonably well-trodden path, but they are not without their complexity and should be taken with that due care and consideration.